Ladies and gentlemen, hit subscribe to this channel right now to my super chat. Thank you. Your support is so greatly appreciated. This is going to be overturned by the Supreme Court. The Supreme Court has essentially already overturned this with the immunity victory and other victories. Trump wins 94% in the Supreme Court. 94% of the time, Democrats are on the wrong side of history and the Constitution, and Trump is on the right side. He is continually proving that what he's doing is constitutional 94% of the time. That's why they're calling him a despot authoritarian. He wins in the Supreme Court months after, 1 year after he won a landslide, every battleground state and the popular vote. Almost everything people have heard about Trump is a lie, or a lie by omission, which is just as bad. Hit subscribe, check it out. This is a Politico article. Trump appeals his criminal conviction in New York hush money case. If it's not overturned at the state level, because I could be wrong, it could be overturned at the state level. But the Supreme Court it essentially already has with the immunity victory. Let's get to this, ladies and gentlemen, really quickly. Before we talk about why the Supreme Court has essentially already overturned the conviction, a state cannot level a Federal Election Commission crime at anyone. That's the DOJ and the federal government. A state cannot, without the DOJ involved, level a federal crime at anyone. And the DOJ and FEC dropped the hush money case. But check this out. The $500 million judgment by Letitia James, pushed by James against Trump, was thrown out. So everything they've done to him in New York will be tossed out. Especially the conviction. He's not even a felon. They say, he's a felon. No, he's not. The entire planet knows that it was politicized. The court itself had numerous conflicts of interest. But check this out, ladies and gentlemen. Let's get to the first victory before the Supreme Court or lower courts or federal or state courts in New York overturn the conviction.
Fox News alert, a New York appeals court just this morning has thrown out President Donald Trump's massive civil fraud penalty. The decision from a 5-panel group in New York's appellate division changed the original decision that stood to cost Trump over $500 million. One appeals judge calling the lower court's penalty an excessive fine that violates the 8th Amendment of the United States Constitution. You might remember that New York Attorney General Letitia James' office says despite this decision, they will not be dropping the case. Let's get some thoughts from Andy McCarthy. He's a former U.S. attorney. He is a Fox News contributor. He is on the phone with us. And last summer, you were helping us every single day as President Trump sat in that courtroom. Letitia James, the AG, she happened to be there as well. And at the time, I remember, Andy, you said that you thought this could be the outcome once the appellate court got a hold of it. What are your thoughts this morning?
Well, I think, Dana, that Trump may be ultimately completely exonerated on this. For now, the penalty goes. There was division in the appeals court about the merits of the underlying suit. But as you point out, what they found basically under an 8th Amendment theory, that's the amendment that prohibits cruel and unusual punishments, there was such a mismatch between whatever wrong was actually established in the trial and the outrageous penalty that was imposed for it, which was, I think, $355 million, which with interest and other costs is already up to about $530 million now because it continued to accrue for a while. That was such a ridiculous mismatch between what the penalty was and whatever the wrong was that was established, that had to go. The court is leaving in place some other what they call injunctive rulings that were made by the court. So some things have to be sorted out, like how much monitoring Trump's organization is going to be under. But he's out from under the most important part of the case, obviously. And I think there could still be an appeal to the highest appeals court in New York, the Court of Appeals, where they will deal with the question that seems to have vexed the appellate division, which is the whole merits of the case and whether Letitia James, the Attorney General in New York State, should have been able to use a consumer protection statute that had never been used in this way to try to establish a fraud case based on sophisticated financial actors, where, this is not a situation that a consumer protection statute was ever meant to apply to.
And
so Deutsche Bank, for example, defended President Trump when James and others said he inflated his net worth, or that Mar-a-Lago was worth only about $17 million because of a tax assessment. This is completely absurd. All of it is completely absurd. They went after Trump, so the legal victories in the Supreme Court and the appellate courts continue for President Trump. The conviction will be overturned. But this, I'm just kind of giving you a trip down memory lane. And by the way, Paul Bartlett, thank you so very much. To my super chat, thank you. You want to give me a super chat and support the channel, greatly appreciate it. Thank you, Paul, as always.
And Andy, we're just getting some new reaction in from the White House right now. If we can pull this up, this is from Trump spokesman Stephen Chung saying, quote, Letitia James' political crusade against President Trump, which is barred by the statute of limitations, and where she ludicrously valued Mar-a-Lago in Palm Beach, Florida, as worth a paltry $18 million, as well as committed a ton of other fatal errors, is just another failed skirmish in the discredited Lawfare campaign against President Trump, his family, and his business that other Democrat prosecutors are dropping left and right. Andy, real quick, final word to you. Letitia James was sitting in the front of that courtroom every day smirking, and looks like she lost today.
She lost, but I think, Bill, Trump is president because of Lawfare. And I think this was just it was a big part of it, but it was just one part of an overarching campaign in which Trump actually won sympathy from even people who weren't particularly sympathetic to him to begin with.
And they want to impeach Trump again when they get the House, if they get the House, which will only help J.D. Vance in 28. E22, thank you so very much. Citizen E22, thank you so very, very, very much. Greatly appreciate it, and I appreciate the kind words. Thanks, everybody. Paul Bartlett in Australia, thank you. Citizen E22, as always, thank you so much for watching.
But who saw if this could be done to him, it could be done to anyone.
Pretty incredible, and much more to come as we parse through this news today. Andy McCarthy, thanks for joining us.
So when it officially happens, it's basically happened already with the immunity victory. When it officially happens, watch the channel. Go to H.A. Goodman when you find out that the Supreme Court, or it could be the appeals court in New York, overturns the hush money conviction. This is another. It's a hoax in a sense that, yes, he was technically convicted, but it was so politicized. The court had so many conflicts of interest. The immunity victory that Trump got in the Supreme Court defends President Trump because Michael Cohen likely lied through his teeth. But Michael Cohen had conversations with the president that was also part of the quote-unquote evidence used against Trump, which, by the way, nothing he did was a campaign finance violation. You have 3 FEC chairmen stating the same thing. But another trip down memory lane. Check it out. eCitizen22, thank you. Paul Bartlett, thank you. To my super chat, greatly, greatly appreciate it, everybody.
Major legal win for President Trump. A New York appeals court just tossed out his civil fraud penalty, ruling that the roughly $500 million fine is excessive and unconstitutional. They did not, though, throw out the entire case. Let's bring in Andy McCarthy, Fox News contributor and former assistant U.S. attorney. So here's what Judge David Friedman said in concurrence. He said, quote, "What emerges from this court's vacating the $500 million disgorgement award, with which I concur, is the frustration of what appears to have been the Attorney General's true aim in bringing this action. Plainly, her ultimate goal was not, quote, market hygiene, as posited by Justice Moulton, but political hygiene, ending with the derailment of President Trump's political career and the destruction of his real estate business." Andy, you thought this case was a stinker from the beginning. What do you think of the judge's decisions?
Well, I think they got it half right, John. Obviously, the penalty had to go. There's kind of 2 tracks, I think, to look at this. One is the penalty, and let's deal with that first, since that's what they got rid of. On an Eighth Amendment theory, that is the constitutional prohibition on cruel and unusual punishments, which applies to the states and which has been applied to gross mismatches between the punishment and the wrong that's proved. This clearly was way, way out of bounds from in terms of $500 billion or $1 million compared to anything that they proved in the case. So I think we've had signals for a long time that that was going to go, and it's appropriate that it did. As far as the merits of the case go, what James did here was, in a very unprecedented way, take a consumer protection statute that's supposed to apply in a situation where you have like a wrongdoing fraudster who defrauds a bunch of people, none of whom is hurt enough to bring a lawsuit. So that's the rationale for having the state come in and do it. This was a totally different situation. This was Trump, a sophisticated financial actor, with his counterparties who were financial institutions and insurance companies and other sophisticated financial actors who didn't need that kind of protection.
Andy, in the prevailing opinion, the judges wrote that the injunctive relief ordered by the court is well crafted to curb defendants' business culture. Is that a ding at the president?
Well, sure it is. What they're saying, I think, Jillian, is that the state did prove, I don't think they proved to the extent that James contended, but they did prove that there were instances where Trump had exaggerated or manipulated the value of his assets, depending on whether he was trying to get a loan or insurance coverage. But the important thing there is that even if you agree with the court that Trump did that intentionally, Trump's own assessments of his assets had an admonition in it encouraging his counterparties to do their own due diligence.
Merry Christmas, everybody. Thank you. And whenever anyone, whether it's a billionaire or just, anyone going to a bank, you're going to, let's say you own a lot of property like President Trump, your valuation might be different from the bank's, and it has nothing to do with criminality. It's just that like real estate agents know a lot more than a lot of bankers what the true value of a home in a sought-after area is. For example, like Mar-a-Lago. There was a real estate agent on Maria Bartiromo that said Mar-a-Lago was worth $1.5 billion. Just the guest house alone was something like $20-30 million or $80 million, something like that. So to think that these officials in New York who were lifelong Democrats could appraise real estate better than President Trump is completely absurd. But there's nothing criminal about trying to prove that your valuation is correct and that another person's valuation is incorrect. That's actually oftentimes good business.
And of course, they were in the business of assessing risk, so it's a very de minimis offense.
Yeah, don't forget, a piece of property or something else is worth what people are willing to pay for it. So
right.
If they think that it's worth something exactly other than somebody says it is, it's up to them to do the due diligence. Well, Letitia James says she's going to appeal to the New York Court of Appeals.
So that didn't work out, and Trump won again. This, ladies and gentlemen, is John Yoo. Speaking to Mark Levin, he talks about how the Supreme Court will overturn it. Essentially already has.
Welcome back, America. We're here with our friend John Yoo, really one of the foremost legal scholars in the country. Former Deputy Assistant Attorney General, UC Berkeley Law Professor, Hoover Institution, visiting fellow, and all-around great guy. John Yoo, you see this case in Manhattan. How bad is it for our nation? How bad is it for our electoral system? How bad is it for the rule of law, for federalism, the whole kit and caboodle?
Mark, thanks for having me back. I am saddened at what this case has now done to our political and constitutional system. It's hard to exaggerate the harm that it's going to do, not just to Donald Trump. He's important, but the more important question is, what does this do to our institutions? As you said, our legal system, our electoral system, our system of federalism and the separation of powers for all future presidents, for all future citizens. First, we have never prosecuted a former president before. This was not because past presidents hadn't done anything bad. It's because we thought it was the best thing for our separation of powers to leave presidents alone. And the reason why is because the Constitution concentrates so much responsibility and authority in the president to take care that the laws are faithfully executed, to protect the country from foreign threats, that we don't want our presidents, when they're making the hardest decisions on behalf of the country, to be worrying about whether they're going to be prosecuted or not. We don't want our presidents to be insurance claims adjusters worrying about risks and balances of their own personal finances and their own personal legal situation. We want them to decide what's best for the country. Now, because this case was so frivolous, because it was based on such concocted legal theories, it opens the door wide now for any DA, and there are 2,500 of them in the country, any DA to sue and prosecute any president, any past president, perhaps any sitting president under the theories that were put forward earlier. I think an even worse problem is for the rule of law, because what we've all learned now, I think, is that prosecutors can destroy.
So this was before the appeals court tossed the $500 million verdict, and before the appeals court opened the door to President Trump going either to the Supreme Court or having the appeals court in New York just toss the conviction. So he's on his way to the conviction being tossed. But let's continue. This is John Yoo talking about the Supreme Court. When it gets to the Supreme Court, will overturn. But the conviction is essentially already overturned. It's just a matter of time before the Supreme Court or a lower court completely overturns the hush money conviction.
A person, they can destroy a person's reputation, his finances, just by investigating them, even before they get to court, just by publicly announcing that they're investigating someone. We have for 230 years relied on prosecutors, on our elected chief executives, governors, and presidents to show, again, statesmanship, to go show good judgment, not to abuse this power. But now what we've seen is that I think the Biden Justice Department and these blue city DAs are abusing this power, not to try to stop crime, but to target individuals because they don't like them, because they're unpopular, and then to find the crimes to fit the man. That is directly a direct assault on the rule of law. And that harms all of us in the country, all the citizens, not just Trump, not just presidents, but you and me and everyone else.
And what about the electoral system when you have one of these DAs deciding that they get to decide or try to decide the outcome of an election through the process? They can make a ambiguous reference to federal law, seize jurisdiction from what is a complex layer of federal authorities and decision makers when it comes to federal election campaign law, let alone seize the authority from federal courts and the Supreme Court to make these decisions, regardless of what the New York courts say up and down the chain. I mean, whatever the New York courts say up and down the chain, that is not the final decision. If the federal Supreme Court decides to step in, that's the final decision for you, New York. So if I'm in California and I see that it worked in New York because we have this lumbering appellate process, but I can interfere with an election, by the time the appellate process catches up with me, so be it. They're going to time it the same way. So this can really become a cancer on the political campaign system of the highest federal official in the United States, and the election there too, no?
Mark, I appreciate what you said in your opening statement, because the Supreme Court has made clear, not just in one offside comment, in 3 very clear decisions, that only the federal government can enforce federal law. Only the Justice Department and the Federal Election Commission can prosecute and bring suit for violations of federal election law. They're the guardians of how federal election should run. And so what happened here is that the DA, approved by this judge, Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
When we come back, John Yoo, that is my question. So should we sit on our hands?
So that's what I have been saying, John. You said it. He's a tremendous legal scholar. Check it out again.
Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism. And the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
They will get a chance to hear it if the appeals court doesn't overturn it first. Okay? Why? Because of the immunity victory. So, again, he will not be... When Democrats are already the wonderful, morally superior among us, wonderful, amazing, brilliant law professors are writing articles, titled "The Supreme Court is Illegitimate." Well, I mean, this is not helping their political party at all. It's hilarious, amusing, sad, and pathetic at the same time. But what's going to take place is that the Supreme Court will continually rule for Trump. Democrats will continually be on the wrong side of the Constitution and history. The conviction will be overturned, so they can't say, "Oh, he's a felon," which nobody believed he was. He won in a landslide. Okay, everybody knew that he was set up, framed. He's just continuing from Russiagate to the hush money conviction to the $500 million judgment that was overturned. All of these are either hoaxes or overt political stunts. The Supreme Court overturned the Colorado State Supreme Court ban. They wanted to kick Trump off the ballot, and that was overturned unanimously. Even the 3 liberal justices reluctantly had to, look at logic and reason. But anyway, let's continue.
We're going to get out of that commercial break because we have word that the Supreme Court has issued a ruling on the extent of presidential immunity from criminal prosecution for conduct alleged to involve official acts during the tenure of President Trump. This is the big one we've been waiting for. It's consequential. It's really interesting that the Supreme Court in 248 years of our history has never actually ruled on this. So it is big and sweeping. And I have our political panel looking over this right now. Andy McCarthy, Chief Justice John Roberts has the writing on this. He's got the pen. Is that significant?
It's very significant. This is the most important case of the term in terms of the long-term interests of the executive branch, in terms of the short-term interests of Donald Trump. And it looks like, at least within the bounds of clear executive authority, what Chief Justice Roberts is saying is that the president clearly has immunity from prosecution. So the question is going to be, again,
So not only did the FEC drop the case, the DOJ dropped the case, it's unconstitutional for the state of New York or any state to level a federal crime without the Department of Justice or the federal government involved. But Michael Cohen and others provided evidence and testimony from the time period of Trump as president in 2017. So you can't use that in a trumped up, no pun intended, politically fueled case in the most blue in Tammany Hall. So that alone, the immunity victory alone, has overturned the conviction. I mean, all of this will take place in 26, in addition to indictments from the Florida grand jury for conspiracy statutes. And then you have the John Bolton trial. That's coming up, also 26, I believe. So, I mean, there's 2026 is going to be a very good year for President Trump and for the millions upon he won the popular vote. So the popular vote of the United States of America.
I think Trey underscored this before, is what is an official act? There's going to be a lot of litigation about that and what's close to the core of clear executive constitutional authority versus the outer ambit of it.
Brett?
Do we have Shannon? Is she going through the paperwork? Shannon, you there?
Yes. Yes, I am here, if you can hear me. Let me read you a little bit of what we have from the court. It does find this. Under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. He is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. That's the first blush we've got on this. It looks like a 6-3 split. We've got the dissent by Justice Sotomayor, Kagan, and Jackson join that. there is a kind of split decision on some of these. Somebody joins in one part, not in another part, but that's the overall holding of the court. So what it means now, we'll have to dig into this and see if they tell us now, how do you decide an official act versus an unofficial act? Because that's going to be critical, having now said the president does have absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. We'll dig in, see how they define those official acts.
If he's speaking to an attorney, okay, it's an official act. If you say, well, they were conspiring to commit a crime, well, that didn't stop the judge from siding with Comey and his attorney that he potentially used to leak information, which was possibly illegal. Okay, there's attorney-client privilege. Even the president has that, so it's an official act.
Acts and look for a little bit more from you from the opinion, but at first blush this looks like it is going to be a win for the argument for presidential immunity when it comes to allegations of criminal activity.
What's interesting is that, you know, I'm sure if you're in the Biden White House, you're paying close attention to this as well, because in the situation that we find ourselves in the utilization of the justices in politics. Let me go to you, Jonathan Turley, for a reaction to this decision so far.
Well, this is along the lines of what many of us anticipated, that the court did not go with absolute immunity on everything, but did say that there's absolute immunity when it comes to core constitutional powers. We're still going through the opinion to see if there's any assistance on where that line is to be drawn. This case is going to have to go back to the district court, which is going to have to try to sort of thread this needle to determine what in the case would not fall under these protections. But this is obviously a win for President Trump in the sense that the special counsel was arguing, as with the lower court, that there was very little immunity here to be concerned with. The counsel for the government was assuring the court that they really didn't have much to be concerned with here in terms of any changes in the status of the case. That's clearly not what won the day. The court here is saying that we do need lines here drawn to protect presidents so they have some breathing room. And you have to sort of wonder how the context affected the justices. I mean, if they want to look at the implications of leaving presidents without protection, they just need to look around the country. Even though Manhattan was not a federal case, it was a political prosecution in the view of many of us that was rather raw and open. And so this is a context that must have concentrated the minds of these justices as they did what Justice Gorsuch said and tried to write for the ages, to have something not for this case, but for future cases and future presidents.
I'm Steve Doocy.
So again, it's blatantly unconstitutional. It's on its way to being appealed at the state level. It might not even get to the Supreme Court. But this is like a legal locomotive, an orange legal locomotive. You can see like Trump's hair, like the silhouette of Trump's hair, you know, on the front of the locomotive, just steaming towards, you know, the conviction being overturned. And like this like orange beam of light on the tracks with, you know, the morally superior, you know, as they see the, you know, Trump train going towards the eventual destination of the conviction being overturned. Anyway, everything they've tried has failed. And you better believe, like, we can go on forever.
Our moment-to-moment coverage of New York versus Trump continues, and the former president's attorney, Todd Blanche, is still delivering his side's closing argument. It sounds like, though, it's coming to a crescendo here. He's once again attacking the credibility of Michael Cohen, central to his closing argument, saying that the government is perfectly happy to have a witness.
By the way, Michael Cohen's testimony, allegedly, possibly, many have stated he lied through his teeth. Not only in Congress, he committed perjury almost certainly like 2 or 3 times. Possibly also when he was answering questions from the Congresswoman who was literally texting Jeffrey Epps. Okay. Real time during one of the congressional hearings. But many people have stated he lied through his teeth under oath. But that's also one reason to throw out the conviction, along with the fact that it's blatantly unconstitutional.
Commit perjury on the stand. The defense could wrap up at any moment, and after that, it's the prosecution's turn. Let's bring in John Yoo, UC Berkeley law professor, former Deputy Assistant Attorney General, and former law clerk for Justice Thomas. Professor, I want to come to you and lay out for our viewers what's happening. Right now, Todd Blanche is laying out the 10 reasons there are reasonable doubt. There are myriad reasons, one of which is, this was all laid out in a 1099 and documents. There was no intent to conceal. But he says something about Michael Cohen, and it's been the thrust of his closing argument. Here's what he said. If there is anything we have learned with this trial, it's that Michael Cohen does not take the oath seriously. He lied to Congress, lied to federal judges. He's a thief. He's literally the MVP of liars. Do you think that's sinking in with the jury?
I hope so, because Michael Cohen could be the worst kind of witness any U.S. or state attorney would ever want to build their whole case on. And I don't actually think you need a list of 10, although I think Todd Blanche should be praised for getting it down to 10. It's really just one, because the jury is there to decide questions of fact. The only real fact that the government has to prove here is, what is Donald Trump's mental state? Did he intend to deceive? And the only person the prosecution put on to prove that was Michael Cohen. So if Todd Blanche can just focus the attack on Cohen's credibility, that destroys the government's whole case.
Professor Yoo, jury instructions can make or break cases. They're critical.
And there was also the issue of confidentiality between the lawyer and the client, which, Michael Cohen obviously never heard of. So, and he even taped President Trump, which found nothing. I mean, there was literally nothing that they ever have against Trump, like nothing. They just hyperventilate all the time. And the lawfare against Trump was unbelievable, and then they say, "Oh, he's on a retaliatory tour. He's going after his political opponents." It's like the political amnesia is just, if it's more than 2 days, they forget about it.
We will learn soon what is in those jury instructions, but it's confounding to me, to Lydia Hu, our producer in the courtroom, to Shannon Bream as I'm reading their notes, that we still don't know that second crime that would elevate this misdemeanor. As Shannon Bream says, I'll quote her, "This is one of those points that seems most ripe for appeal." I presume, like any other defendant, Donald Trump would have a Sixth Amendment right to know the charges against him, wouldn't he?
That's a good point. There's a serious question about whether the prosecution has actually violated the Constitution in the way they've concealed the second crime. Recall that the first crime is just a misdemeanor, this bookkeeping entry business. It only becomes a felony, which is something worth jail time, if it's used to cover up or to enable some greater felony. The prosecution has still to tell us what that second felony is. It's actually hard for the jury to decide whether Donald Trump's guilty or not if they don't actually know what the crime is. Now, a good judge, an impartial judge, would send this case back to the prosecutors and say, you can't proceed any further. Instead, Judge Merchan just sort of let it go, see what's going to happen. He'll still have another chance, I think, to decide whether the whole case should be thrown out because of that legal vulnerability on the part of the prosecution.
Do you think he'll take that chance?
I hate to say it, I don't think so. Every time that Judge Merchan has had a really serious choice in this trial, he has sided with DA Alvin Bragg. Maybe that's the case with other judges in New York City these days. But I think the cautious thing to do, especially when we have crossed the Rubicon to allow the first prosecution of an American president in the history of the country, you would want everything to be shipshape and buttoned up. And instead, this has been a kind of, how would you put it, just sort of the Judge Merchan has become a free-form trial where he's calling really difficult questions on the fly. And I think he could have a serious problem on appeal when several, 3 or 4, right, reserved appellate judges can take a look at this.
It might not even get to the Supreme Court. Okay, the appeals court in New York will toss the conviction just the way they tossed the $500 million fine, which was completely outlandish.
Professor Yoo, thank you very much. Your expertise is always spot on. Appreciate it. Emily.
So this is Hans A. von Spakovsky, and great name, and he is a renowned former FEC chairman. Check it out. This is what he thinks of the conviction.
Reaction Francis Hakes does. This is a travesty, a miscarriage of justice. This was a phony prosecution from the very beginning. And for this jury, think about how many weeks this trial went on, how many witnesses came in, and in the very short time that the jury was out, they decided he was guilty on all 34 charges. This is a damage to the reputation of the American justice system like we have never seen. I have a colleague just got back from a conference overseas, and the reaction of lawyers and people there was that the United States has now gotten to be like the countries they are from, where the government uses its law enforcement powers to go after its political opponents. And that, I think, is exactly what happened here.
Hans, what was the underlying federal campaign violation? Did we ever find that out?
Well, you know, there was nothing in the original indictment about any kind of federal campaign violation. They kept saying that the legal expenses, which is what were listed in the business records, should have been a campaign-related expense, the payment that was made to Stormy Daniels. But as Brad Smith, I know, would have testified, under the test applied by the FEC, this was not a campaign-related expense, period. There's just no question about that. So for this jury to say that, oh yeah, he violated federal campaign finance laws and that justifies the underlying verdict, that is such an egregious mistake that at the Court of Appeals in New York, when they get this case, they ought to reverse this almost immediately because of this and so many other mistakes made in the case.
How many do you count? How many mistakes?
I lost count of how many errors were made by this judge and by the prosecution. I mean, the judge let in all kinds of irrelevant evidence that had no bearing on the charges against the president, but were obviously there to blacken the character of Donald Trump. The judge shouldn't have even been on the case. He should have recused himself because of his personal family dealings, his daughter's involvement, his making political contributions in violation of the ethics rules in New York.
That's another thing. Where are the judges making contributions to Donald Trump? You have judges making contributions to Hillary Clinton, and it's like, and then they're looking at they're overseeing a case of, you know, against Trump, and the verdict is of course against Trump. It's like, what? It's unbelievable.
There are just so many mistakes and errors he made that I don't see how a Court of Appeals could not overturn this verdict.
So either the Court of Appeals, likely the Court of Appeals, but the Supreme Court, definitely, the verdict will be overturned in 26, which will be yet another moment.
The Manhattan DA says he will not appear on Capitol Hill today as House Republicans hold a hearing on former President Trump's New York trial. Bragg citing scheduling conflicts. He is set to testify, though, on July 12th, just one day after Trump's sentencing. Federal Election Commissioner Trey Traynor and Missouri Attorney General Andrew Bailey set to testify today.
Who is now essentially the number 2 at the FBI. And Trey Traynor, you have Bradley Smith, you just heard Hanze von Spakovsky. 3 former Federal Election Commission chairmen stated it was not a campaign finance violation what Trump did to pay Stormy. And it was Michael Cohen who paid Stormy, by the way. Trump didn't even use, there was no money from Trump. It was Michael Cohen who used the money. And there's no evidence that Trump told him to do anything. Likely, you know, that was the understanding. But there's no evidence. I mean, it's so obvious this will be overturned, and it'll happen in 26.
Today at today's hearing, and they join me now. Trey, you notice I emphasized the election in your title. I guess we're finally set to hear from somebody who actually understands how election law works. Juan Merchan cannot silence you. What are the top points, Trey, you're going to try and drive home today?
Well, the most important point is that Judge Merchan completely obliterated what's been longstanding federal election law with the jury charge that he gave, asking the jury whether Donald Trump had willfully contributed to a campaign. And the legal standard has long been knowing and willful standard, so he's completely upended that standard. And it's one of those things where the Department of Justice should have intervened early in this case and protected the jurisdiction of the federal government to enforce federal campaign finance law. They didn't. They didn't protect the jurisdiction of the Federal Election Commission. And it's completely perplexing why they didn't do that. There's long-standing Supreme Court precedent that says that they should have.
And it's just how law works. People always fight over jurisdiction. They never give that up. And in this case, it was ceded so easily. Andrew, Democrats, of course, are going to try and flip the script, calling today's hearing playing politics. And they're going to make this point, Andrew, A.G. Bailey. They merely follow the facts and the law up there in New York City. How will you cut the legs out from under that argument?
Well, they bent the law to meet the facts in a specious legal charge. There's an unseemly amount of prosecutorial misconduct. And at the end of the day, what that does is it injects both statutory and constitutional violations into the process from the charging document onto the jury deliberations. And so this is a legally errant conviction. It's not a legally valid conviction. And that emphasizes the illicit nature of the witch hunt prosecution. And it's important that the American people understand that the goal here was never to convict President Trump of a crime. It was always to remove him from the campaign trail. Now, this is a presidential candidate that has a right to speak and that we as a people have a right to access. This has done immeasurable damage to our democratic republic, and we've got to hold wrongdoers accountable.
Let's focus on this Matthew Colangelo, Alvin Bragg dichotomy here at A.G. Bailey, because the number 3 starter right now in the Yankees rotation is not waving his hand and saying, please send me to single A so I can ply my craft. What possible reason could Matthew Colangelo, the number 3 at the Department of Justice, have to leave the DOJ, go down to the Manhattan DA, if not for his desire to help the Democrats and get Trump?
Yeah, the DOJ may not have intervened to reassert the jurisdiction of the FEC. That's the appropriate legal avenue for the DOJ. But instead, what they did was deploy resources to the state of New York in the form of Matthew Colangelo, like you said, the former third-ranking official in Biden's Department of Justice, who led the trial court prosecution against President Trump on behalf of Alvin Bragg. So he takes a pay cut to go work in state court. He's politically motivated. Those prosecutors should have been disqualified from prosecuting that case. There was no case to begin with. A subsequent prosecutor that the court could have appointed would have identified that and dismissed it before it got this far. And again, Biden is behind this whole thing. I mean, he has managed the Department of Justice that also administers grants on behalf of the Soros-backed Vera Institute to Alvin Bragg's office with the intent of dismantling the criminal justice system. So while Alvin Bragg is ignoring crime in the subways and on the city streets, he is being trained to weaponize the criminal justice system against Biden's political opponents.
Trey, quick final word to you. If we don't stop this lawfare right now in its tracks, can our century-old justice system survive?
No, it can't. And we have a big threat to the First Amendment and whether or not candidates can actually run for office in any state, because we'll have turned loose all the prosecutors across the country, whether they be state or local prosecutors, to go after individual candidates for perceived violations of campaign finance law.
Exactly. So former FEC Chairman Trey Traynor said it brilliantly, along with Hans Evan Spakovsky, and you'll hear Bradley Smith in a second, the other FEC chairman. And if a state prosecutor can accuse anyone of a federal campaign finance violation without the FEC involved, without the DOJ, without the federal government involved, it's not only blatantly unconstitutional, but any prosecutor in any state could go after any politician, left or right, Democrat or Republican. But we have a separation between states and the federal government for a reason. But anyway, check this out.
What kind of precedent this would set. The prosecution says it influenced the campaign. As you point out, there's 1,000 things that influence a campaign in a positive way. Maybe I want to buy a $5,000 suit with my own money. There's a lot of things. Maybe I want to buy an old used Chevy and trade in my brand new Cadillac so it looks better in the campaign. That positively influences the campaign. Let me ask you something. members of Congress, we know this as a matter of fact, settled ethics complaints involving sexual harassment. They created this slush fund with taxpayer dollars to quiet the accusers. Non-disclosure agreements, if you will. Hush money. We can use the same phrase. They didn't want their constituents to know. Many of them running for re-election as incumbents. They're using tax dollars. It influences the campaign. Why aren't they indicted?
Well, we know why they're not indicted, right? Because we don't want to indict them. But no, it's a good example of things that influence the campaign. And it's worth noting that under the FEC's regulations, if you're an incumbent office holder, you're presumed to be running for re-election. So you're all presumed to be candidates unless they've announced that they're not seeking re-election. So they would be candidates, and this is something that they probably did to influence their future campaign or their perception as office holders. And one thing that's worth adding here, Mark, is because I hear this from people all the time, and even some other, election people who know election law, lawyers and some former other commissioners will say, yes, but it was to influence an election. But the FEC in its regulations very specifically rejected the idea that even as to whether it was primarily to influence the election or not, and choosing instead this test that it has to be an obligation that was created for the election. In other words, they didn't want to get into the question of trying to guess, well, did they do this primarily for the election or primarily for personal purposes? And it's very specific about that in the regulations. And I think that's a very important point that people need to keep in mind. And that was done actually to make it more objective and actually to prevent candidates from using their campaign funds for personal use. But, that's the flip side. And I tell people, imagine if you're a lawyer for the Trump campaign and you want to do it all right. You've got one provision of the statute says I have to pay it with the campaign funds. Another provision seems to say I can't pay it with campaign funds. Somebody's going to get them coming or going, and that's part of the problem.
So if you're a lawyer for the Trump campaign or the coming Trump campaign, you would do pretty much what Donald Trump did. No campaign money, consult your private lawyer, and they enter into these non-disclosure agreements. Greg, let me ask you this. Isn't the real issue here is people were actually paid under the non-disclosure agreements and then they violated the non-disclosure agreements? I don't see them giving the money back.
Oh, you're absolutely right. I think it's malpractice for the attorney for Stormy Daniels to say, go ahead and talk while the case is pending as to whether or not it's a valid and enforceable non-disclosure agreement. So it's stunning to me. But to Bradley's point, not everything that benefits a candidate is considered to be a campaign expense. Professor Smith wrote that in one of his op-eds, and he's absolutely right. If there is a dual purpose or a secondary purpose, it's not a campaign expense. And moreover, the media rushed and said, oh, Cohen pled guilty, the president must be guilty. That's utter nonsense. First of all, under the Federal Campaign Election Act and other related laws that criminalize violations, there has to be knowledge. You have to show that there was a knowing and deliberate violation of the law in order for it to be criminal. Well, most candidates don't know the election law. Heck, a lot of lawyers don't understand election laws. This gentleman, the former commissioner, the Federal Election Commission, chairman, he knows election law. He may be just about the only one in America who really truly knows it.
And so here you have, ladies and gentlemen, Bradley Smith explaining exactly why, the former FEC chairman explaining exactly why the conviction will be overturned. Okay, there was no crime.
Oh, Trump's indictment looks like a perversion of campaign finance laws. There are no crimes committed, or at least that's what Bradley Smith, Capital University law professor, chairman, and founder of the Institute for Free Speech. Mr. Smith is a former FEC commissioner, and he's the co-author of Voting Rights and Election Law. Brad, you're writing in the Wall Street Journal. We've been trying to get our paws on you for the show. Thank you for coming on. You're saying there was no crime.
My pleasure.
There was no crime to start with. Even if there were some issues on the so-called filing of business papers, there was still no crime.
Right. I've had a bit more time. I had the commercial break to look at the indictment a bit more, and it looks like the last couple pages of the indictment do intend to say that the crime was not disclosing campaign contributions, although they never cite a specific government statute. But here's the problem here. The prosecutor's theory goes like this. Federal law says it's a campaign contribution to make an expenditure for the purpose of influencing a federal election. Those are the key words, for the purpose of influencing. And he says, well, these payments were intended to keep her quiet, which would help the campaign, so they were for the purpose of influencing the campaign. Now, first, these payments could have been made for other reasons, right? To prevent embarrassment to his family, to preserve marital harmony, all kinds of things. But none of that really matters, because the standard here for the purpose of influencing is not a subjective standard, it's an objective one. So if I go out and I want to pay for TV ads that say, Donald Trump is a ding-dong daddy from Dumas Bay, because I think that's really going to help him win re-election, it doesn't matter. Legally, that will not be for the purpose of influencing an election, no matter what my own subjective purpose was, right? It's subjective. So what counts as campaign expenditures? Things like, you don't hire a campaign manager unless you're running for office. Right. You don't take out ads saying vote for me unless you're running for office. You don't hire or establish field offices unless you're running for office. But other things you do. For example, you buy clothes whether you're running for office or not. So the fact that I'm running for office and I say, I've got to look good, and I go out and I buy a $6,000 suit that I would never otherwise buy, doesn't make it a campaign expenditure. It doesn't count. Same if I say I need a $600 haircut. Or to take a more perhaps relevant example, suppose I'm a business owner and I say I'm going to run for office, and I go to my corporate lawyer and I say, there's some lawsuits against our corporation. I think they're bogus, but let's get rid of them so they don't interfere with my run. Just settle those lawsuits. You can't settle those with campaign funds. It's not a campaign expense, even though that person's subjective purpose was to influence the campaign.
By the way,
so that's a very important part of the law.
I know. I was very impressed with the $6,000 suit. That must have been a custom bespoke suit. In your op-ed piece, it was $4,000. But I know we've had an inflation problem in the last couple of weeks. But your point here, I'm just having some fun. But your point here, Brad, if I understand it, is that you buy a suit, you get a nice haircut, whatever. You're doing it directly for the campaign. Is that correct? That's the point you're making. But if you want to defend,
well, the point is, yeah.
If you want to defend yourself, your honor, keep it away from your wife, that kind of thing, which, by the way, is unproven. I mean, Stormy Daniels keeps telling people she didn't have an affair. Nobody wants to listen to her, but that's perhaps grist for another segment. But if that does not qualify because it's not directly for the campaign. Is that right? Is that my correct interpretation?
It actually goes further than that. Even though you bought that suit because you were running for office and want it to look good, it's still not a campaign expenditure.
Oh.
Why? Because you buy clothes. You buy clothes whether you're running for office or not, right? And so anything that people might do, even if they're not running for office, doesn't count. So people pay money. For example, they pay divorce attorneys to try to seal up their divorce records so that those don't become an embarrassment of the campaign.
Right.
Their purpose may be to influence the campaign, but it's an expenditure that somebody who wasn't running for office might also make. The only things that count are things that come directly out of the fact that you're campaigning. And the flip side of this is that it's actually illegal to convert your campaign funds then to personal use. So it's actually illegal to use your campaign funds to buy that suit. It's illegal to use your campaign funds to pay a lawyer to seal your divorce records because you think that will help your campaign. And this is the real problem you have here. Not only is there, I think, not a campaign finance violation, this underlying alleged violation, but it's a situation where they're going to get Trump coming or going, because I think, knowing Bragg, and you've set the political stage very well, had Trump paid for this with campaign funds, I think we can feel pretty certain that he would be being charged today with having illegally converted his campaign funds to personal use. In other words, they were going to get him coming or going. If he pays for it with campaign funds, they were going to say it was illegal personal use. If he doesn't pay this money with campaign funds, which was the reality, now they say, oh, well, he should have used campaign funds. And that's, the antithesis of the rule of law, where you set up a system where no matter what course of action a person takes, they're going to be held in violation of it.
So, ladies and gentlemen, the appeal process is in the works. He's about to get it overturned. The appeals court's probably going to overturn it before the Supreme Court. Be here tomorrow at about 11:30 a.m. Eastern. We'll have the live stream. We'll do 2 or 3 a day from here on out. 2026 is going to be awesome. It's going to be an amazing year, everybody. An amazing year. And 2026, you'll see indictments. You'll see the hush money conviction, absurd conviction overturned. So many things. There will finally be legal accountability. Rome wasn't built in a day. But anyway, ladies and gentlemen, hit subscribe. Yes, the Supreme Court can and will overturn the hush money conviction. It probably will be overturned in the appeals court in New York on the state level. But that process is now in full effect.